Good morning, everyone. Thank you, Neil, for your kind introduction and for outing my chocolate habit, and for inviting me here today. It is a pleasure. I'd like to begin by commending FAIR for bringing together this distinguished group of experts to tackle a very complex and challenging issue. How do we improve recovery for harmed investors? We all know the reality. It is very difficult for harmed investors to get their money back. There's no one organization, no one solution that can make all investors whole. We must continue to strive to come up with more effective solutions to this challenge. It requires a commitment to a common purpose, cooperation, and action. And that's why we're here today. We all have a role to play. The OSC, as a securities regulator, is responsible for making the rules regarding investor protection and fair and efficient markets, overseeing compliance with those rules, and monitoring risk, and deterring misconduct through robust regulatory enforcement. We have limited powers with respect to investor recovery, but we're doing our best to recover what money we can and protect investors within our mandate and within our regulatory framework. Like everyone, our resources are finite. We have to find new ways to increase our reach, increase our scope. Our focus is on expanding investigative and enforcement tools, on continuing to build our domestic and international partnerships, and enhancing our regulatory framework to meet the challenges both of today and tomorrow. Let me give you a few examples. The single most important tool available to the OSC to facilitate recovery for victims of fraud is the freeze order power. The simple truth is that people who perpetrate fraud don't pay monetary fines. It's virtually impossible to recover stolen money after the fact. By the time the person has been caught and sanctioned, the money is long gone. It's been spent or hidden, and the likelihood of finding it is extremely low. The ability to freeze funds at an early stage of the investigation prevents assets from being liquidated or transferred abroad. And that means that investors have a better chance of getting their money back. The Commission has had the freeze order power since 1994. Freeze orders issued by the Commission, they're temporary and they have to be continued by court order. Until last year, the courts have been holding the OSC to a very high standard of proof in the case against the respondent in order to continue freeze orders. In 2014, the Ontario government amended the Securities Act to expand the types of freeze directions the OSC can issue, and also to introduce a statutory test that courts must consider when deciding whether to continue a freeze order. Specifically, the test introduced requires the court to consider the public interest. And this is intended to facilitate the OSC's ability to continue the freeze orders while staff's investigation and prosecution of the case against the respondent continues. In the last fiscal year, that's the year ending March 31, 2015, the OSC issued 26 freeze orders involving a total of $9 million in assets. This compares to 8 freeze orders last year and $1.3 million of assets. If we're successful in bringing a case against the respondent and there is a disgorgement order or other sanctions order, the money that is frozen, or the money that's collected under the sanctions order, can be paid out to investors under a variety of mechanisms, and I'm going to mention 4. The first, a court-appointed receiver. Second, a third-party claims manager. Third, a direct allocation by the Commission. And fourth, a distribution by the Civil Remedies for Illicit Activities Office of Ontario, otherwise known as CREA. So for example, the largest distribution made to investors was the Portis case. In 2005, KPMG was by court order appointed receiver. And by 2009, investors had been paid out 95% of the $730 million invested. An example at the more modest end of the spectrum is the Nest Acquisitions case. It involved a fraudulent distribution where staff were able to freeze approximately $72,000, which was later disgorged to the Commission under a sanctions order. Through banking records, staff were able to identify a small number of harmed investors, approximately 33. After the matter was concluded in 2013, staff were able to locate 2/3 of those investors and pay back $56,000. Although the money disgorged was only 7.5% of the monies lost, this is an example of an important step in the right direction. In 2011, the OSC added the fourth mechanism that I mentioned. That's through an information sharing memorandum of understanding with the Office of Civil Remedies for Illicit Activities, or CREA. And I know it's early, but I am going to say a few words about Ontario's civil forfeiture law. CREA can, with a court order, take possession of property that it has determined, that a court has determined to be a proceed of unlawful activity, search for the people who suffered loss or harm as a result of that unlawful activity, and use the property to compensate them. The OSC's partnership with CREA allows us to leverage their capacity and ability to advertise for harmed investors, process and adjudicate claims for the money, and make large-scale distributions, all under the auspices of the Attorney General's Office of Ontario. The first file that we referred to CREA was Altar Energy. It involved approximately $650,000 from 120 investors. During the OSC's investigation, staff were able to freeze close to $200,000 held in various bank accounts of the respondents, which represented approximately 30% of the money raised. A distribution of those frozen funds ultimately was made by CREA to investors. We're currently working with CREA on two other files, both involving frozen funds, one around $580,000 and the other $240,000, both representing approximately 35% of investor losses. Staff are also in the process of referring a third case to CREA, which we expect will ultimately result in the largest distribution through CREA to date. I'd like to turn to other new tools. We're also making better use of our resources by introducing new tools and enforcement policies. As you know, one of the most important responsibilities of securities regulators, especially from the perspective of confidence and trust in our markets, is enforcement. A robust, visible enforcement program is essential to protecting investors from future harm and sending a strong, clear message of deterrence to wrongdoers. I'd like to point out that the OSC has enhanced our credit for cooperation and no enforcement program, implemented no contest settlements, and published proposals for a whistleblower program. The OSC introduced no contest settlements last year after lengthy consultations with stakeholders, and we're the only securities regulator in Canada with no contest settlements. No contest settlements, as we'll hear later today, will be used only for cases that meet strict eligibility requirements. For example, respondents must demonstrate that they accept responsibility through clear and concrete action, and that includes compensating investors. Criminal and other forms of misconduct are not eligible. In fact, no contest settlements are intended to help free up resources to pursue more criminal and quasi-criminal cases. Settlement agreements can be one of the most effective ways to get money back to harmed investors because the respondents themselves are in the best position to know which investors they need to compensate. And they carry out the compensation program under regulatory oversight of the OSC as part of the settlement agreement, and it's at no cost to investors. Let me give you an example. Late last year, the OSC approved a no-contest settlement with TD Waterhouse Private Investment Council, TD Waterhouse Canada, and TD Investment Services. The settlement related to alleged inadequacies in supervisory controls, which resulted in investors paying excess fees. The respondents agreed to pay $13.5 million in compensation to all harmed investors, including compensation for foregone opportunity costs. In February this year, staff published a consultation paper exploring a whistleblower program to encourage the reporting of serious misconduct under Ontario securities law to the OSC. Our whistleblower program would be another first for securities regulators in Canada, and we think it would result in real-time tips giving us access to information relating to accounting and disclosure violations, insider trading, registrant misconduct, and other complex cases that may otherwise be difficult for us to detect. And it might facilitate more settlements like the TD Bank settlement, where the respondent pays compensation to harmed investors at no cost to investors. Under our program, a whistleblower could be awarded a financial incentive of up to $1.5 million, and possibly more, upon the final resolution of an administrative enforcement matter. The OSC plans to publish a proposed whistleblower policy for public comment on Wednesday, so that's this week, stay tuned. We look forward to receiving your comments, and subject to comments, we'll be aiming to launch the program in spring of next year. A robust securities enforcement program needs to cover the full spectrum of financial misconduct, including criminal. Those investors, those individuals who have no respect for the law, who prey on investors and repeatedly defy rules. That's what the public expects and quite frankly deserves. So as a regulatory agency, what can we do? We can address financial crime in ways that we haven't previously been able to do by looking beyond jurisdictional boundaries, by working with the right officials, with the right mindset, who share a common vision. In 2013, we established the Joint Serious Offenses Unit, JSOD, an enforcement partnership between the OSC, the RCMP Financial Crime Program, and the Ontario Provincial Police Anti-Rackets Branch. This was a significant step forward in our ability to investigate and prosecute crime. Here's how it works. The team combines police resources and criminal code tools, such as the ability to issue search warrants and do undercover work, with the OSC's specialized expertise, which includes litigators, forensic accountants, and a team of forensic computer experts. And we're seeing results. In just 2.5 years, JSOD has issued over 119 search warrants, has 10 matters in investigation, and has 14 matters before the courts. We're building on the success of JSOD and our partnership with the RCMP. The RCMP recently moved its team, its financial crime unit of 30 people, to be co-located with the OSC's offices at 20 Queen Street West. We now have the capacity to take on more complex cases, and the impact will be intensified. Today, these investigations, as you know, they're not just in Canada, they are global. So this means not only our domestic partnerships, but our international partnerships are vital. Much of the cross-border investigative work is done through IOSCO, that's the International Organization for Securities Commissions, and IOSCO's multilateral memorandum of understanding, the MMOU. Currently, there are 105 signatories. Canada and the US in particular do a lot of work together. In the OSCE's last fiscal year, we received 38 requests from the SEC and other US agencies, and in turn we made 19 requests of them. But we cannot stop there. We always, there's more that needs to be done in an increasingly sophisticated world of global operators who defy the law. At the OSC, we are committed to advancing investor protection and supporting retail investors. And we're doing it by expanding the OSC's investor engagement, education, and outreach. In the spring, we took a major step. The OSC integrated the Investor Education Fund into the OSC, and we combined it with the Office of the Investor. The new Investor Office leads the OSC's initiative to better identify and understand investor issues and concerns, and it does so through investor engagement and research. The office is also the investor's voice internally at the OSC. It champions investor protection and ensures that investor perspectives and concerns are considered and addressed in the policy and operational activities of the OSC. We have a new director to lead this office, Tyler Fleming, who's with us here today, and I encourage you all to say hello to Tyler. Many of you know Tyler. He's joined us from the Ombudsman's Office for Banking Services and Investments. And very shortly, Tyler and his team will be reintroducing the new office to investors and other stakeholders. We're also committed to advancing investor protection and support for retail investors by continuing to examine the standard of advisor conduct. Is the present definition of the standard of care and suitability robust enough? Or can outcomes for investors be enhanced through the issuance of additional guidance or the introduction of a new standard of advisor conduct, the best interest standard? We are continuing to develop and evaluate regulatory reform proposals to address these concerns, and we look forward to further engaging with you on these issues as our policy development continues. These are just a few ways in which the OSC is striving to improve investor outcomes. I look forward to the panel discussions today. They look great. And hearing your thoughts and insights on how we can all work together to improve investor recovery. Thank you.